Hello everyone, I'm Professor Paul Carrier of the Western Michigan University Thomas M. Cooley Law School, and I'd like to provide some information with regard to the materials assigned for Class 5 in our sales class. Before I do that, however, I would like to cover at least a little bit of what we did last week. Last week, as you recall, in Class 4, we covered quite a lot of information. And the reason why I didn't split it up is because that information with regard to the obligations of various parties on negotiable instruments is so connected. There's the obligation of a surety. There's the obligation of a maker. There are obligations of accommodation parties. It's very difficult to break that up and maintain continuity. And therefore, we covered it all in one class. Understood, it's a lot of material. Today's is not nearly as bad. But let me go over a few highlights from last time so you understand the global aspect. The primary issue covered last week from a global perspective is the concept that some parties are more responsible than other responsible parties. And so if somebody is primarily responsible, he, she, or it should be the one paying off a negotiable instrument and not other parties who, for example, sign as an accommodation party or guarantor only to ensure that credit be extended. Okay? If your father signs your car loan, but you're the one who signs the car loan first, you should be the one to pay. And your father or your mother, if she's the co-signer, would pay only when you cannot. You see there's a hierarchy of who should pay. Well, the Articles 3 and 4 most assuredly recognize that same concept. And there are certain benefits or certain common law rules that favor these secondarily liable parties. They include exoneration, subrogation, contribution, and rights to collaterals. Another important feature of secondary liability. If somebody asserting the right to payment on a negotiable instrument meets with a primarily responsible party, typically it's the maker of a promissory note, and those two parties, without the assistance, knowledge, or participation of a secondarily liable party, agree to something that could work damage to that non-involved secondarily liable party, that secondarily liable party should be discharged to the extent of the damage. Perhaps a simple example would be the best. Person asserting the right to payment on a note meets with the original maker of the note, and endorsers who have signed the document and have liability are not involved and are not even notified. If the creditor agrees to give the primarily responsible party more time to pay without the participation of other parties, that is a benefit. And what happens if, in the interim, from due date to the grace period given by the party asserting the right to payment to the primarily responsible party, that primarily responsible party goes bankrupt? The person could have paid maturity date. Time was given, and in between the time given and the new date to payment, that primarily responsible party goes bankrupt. You can see the damage that is vested upon, that is imposed upon secondarily liable parties. And so absent participation in that or proper notice, those secondarily liable parties should also be discharged because it was an agreement to which they were not part that led to damage that should not have happened. Had they been at least alerted, they could have stepped up and protected themselves. Okay? So that's another concept. Guarantee of collection versus guarantee of payment. When you have an accommodation party who guarantees payment, he or she has joint and several liability. If he or she guarantees collection only, he or she is claiming to the public at large that he or she is only secondarily liable and is only responsible after the first party who's primarily responsible has been approached and he or she has been found partially or fully non-collectible. That is only when the secondarily liable party who opts for guarantee of collection only would be responsible to make a payment. And in fact, it's very much like exoneration, where the exoneration is the idea where the secondarily liable party goes to court where there's a primary obligor, and the court will then give the secondarily liable party a ruling stating, you are secondarily liable, the other party is primarily liable, the person who's asserting the right to payment has to go to the primarily liable party first. And only after that can come back to you. This is the same idea as that. People who take on secondary liability this way are warning the public that you must go after other parties first, and only when they are not collectible can you come after me. Okay? Another concept very briefly when we talked about drafts particularly. It can involve a promissory note with the maker and this concept of acceptance, but let's just stick right now with the concept of a draft. When a drawer writes a draft, the draft, which is a check, suspends the obligation to pay for the underlying goods, for example. In the sale of goods, you write a check. While the check's floating, the right to sue for the goods or for the price of the goods is suspended because it is merged into this piece of paper, this draft, this check that's floating around. And so while the check is still floating around, the person who has the right ultimately to be paid on that draft cannot go after the drawer. He or she has to go to the drawee bank first, and he must, or she must, or it must present the check, which may have certain formalities that need to be met. The bank then has to dishonor it, right? We're not recognizing this negotiable instrument. It's not valid to us. And at that point, the primary obligation, which was suspended, renews. And then the party who's seeking to collect, who's unable to, based on presentment, dishonor, and in certain cases, notice of dishonor is required, he or she can go after the person for the underlying primary obligation, the contract for the sale of goods. Okay, now just very briefly, today's material is not overly complicated, but I'd like to make a few points as you're working through the materials. First, Article 3 deals with bank drafts, your ordinary checking accounts. So does Article 4. Article 4 is a set of rules that govern the customer-bank relationship. And therefore, you might find articles in or provisions in Article 3 as well as provisions in Article 4 that could deal with the same situation. In that case, you apply the Article 4 provisions first. Okay? And it's only when something in Article 4 doesn't cover what is needed that you resort to Article 3 when you're dealing with bank checks, whether they be personal or corporate, but with this banking checking relationship. Okay? The most important rule there is probably Article 4-401, the properly payable rule. And what that says, as a default rule, is that banks who are holding drawers' funds must pay drafts that are submitted to them in appropriate ways. And so where there's the amount stated, there's the proper signature, the payee's identified, and there's money in the drawer's account, the banks must pay that. And where the bank fails to pay that properly, the bank has to fix that problem, not with the payee, but with the drawer. Also, if the bank actually makes a payment that it should not have, then the bank has to recredit the drawer's account to that amount that was improperly paid. For example, if there's some kind of forgery the bank's responsible for, and the bank pays it, the bank has to recredit the drawer's account for the money that was not properly payable, and then the bank can go after the person who committed the fraud, the forgery, if he or she's collectible. But it's not the drawer's fault, it's the drawee bank's responsibility. One of the cases informs us that banks are allowed to change their obligation with regard to what is and is not properly payable by the agreement, but so long as banks don't go too far so as to remove basic liability for acting reasonably or with due diligence. When the bank is not allowed to absolve itself of any responsibility with regard to the properly payable rule. Okay? Article 4-402 concerns a bank's responsibility for wrongful dishonor. If the bank wrongfully dishonors a check, the drawer might suffer some damage from that wrongful dishonor. And if he or she does, he or she is entitled, or it is entitled to recompense, which could include attorney's fees, although they're not specifically mentioned, because of the bank's violation of the property payable rule. Today's material also sets out some information with regard to the right of set-off. There's a common law right to set off, but there is also respect of that right in banking transactions, which are often covered by contractual clauses in the agreement between bank and customer. And the bank has the right to set off from a checking account other debts owed to it by the same party. Example being, if you have a checking account, you also have a credit card account, and you don't pay your credit card account properly, the bank probably has the right to reduce your checking account by the amount that was owed on the credit card. Okay, so that's the idea of set-off. You don't owe some money with regard to your checking account specifically, but you owe us some money with another account you have with us at the bank, and you haven't paid that, you're in violation, and we can take money out of the checking account to cover what you didn't pay with regard to some other obligation that you have with the bank. Okay? Questions on that are whether or not the debt is matured. That is one of the cases we cover. The final thing that we cover in today's material deals with stop payment orders. People who have bank accounts have to follow certain rules, but they should have the ability to notify the bank and have the bank stop payment on a check. And then you don't have to worry about the properly payable rule. The bank just says, no, our client, the drawer, has told us not to pay this check. We are not. Now go back to the drawer and figure out what went wrong with him, her, or it, because it's no longer our responsibility. The check was written, the draft was written, but we were told before payment not to pay it. And that's exactly what we did according to our client instructions. You go after him or her or it now to figure out what went wrong. There are certain things that banks have to watch out for, certain things where it's liable, it's not liable, so you pick up that a little bit. There's also the distinction of whether or not a client with an account can stop payment on a cashier's check. And the answer to that is basically no. Keep in mind, when you get a cashier's or teller's check, that's where you hand over the cash, or your bank account is actually debited. So the money is taken away from you and held by the bank on its own account. And then it writes its draft. It writes its check to someone else. That bank, with now its money, might have the right to stop payment. But the person who went and got that cashier's check or teller's check cannot tell the bank when or whether it can stop payment on that check. He or she has lost that right. It's a right that belongs. If you write the check, you can stop payment if you do it in time and follow appropriate rules. If you give the money for the bank to write its own check, only the bank can stop. You cannot. You can try, but the bank is not responsible if it pays out on a cashier's or a teller's check over your objection, because you've lost that right, because the money now is coming from the bank's account and not from your own. Well, I hope that helps, and I promise you that we'll clarify those concepts, certainly the ones for Article 4 during the class period. Further, if time permits, we might be able to look at one or two more problems from the week 4 material that we did not have the time to cover last week. Okay?